Hi everyone, welcome to Civil Procedure. This is Professor Bernstein, or the disembodied voice of Professor Bernstein, here to talk about what it is that we're doing here this semester. So civil procedure is something that underlies a lot of what you learn about in law school and underlies a lot of cases that you'll be reading for the rest of your careers. But it's a little bit hard to spot if you don't know what to look for. So in this class, we learn about what you should look for. And the first question is, what is this thing called civil procedure? Maybe a good way of approaching it is just to break down word by word what we're talking about. So start with procedure. What do we mean when we say legal procedure? For the most part, in law, we distinguish between something called substance or substantive law and procedure or procedural law. Substantive law is what determines whether someone is liable to someone for some violation of a legal duty or an infringement of their right. So what is that right? What is that duty? What constitutes a violation? All of those things are substantive law. Procedure determines how it is that you go about vindicating those rights and imposing those obligations through the litigation system. How does a court get power over the litigants? How does a court have authority to hear a case? What do you have to do to get a lawsuit going? And what can you do to make it stop? What are your obligations to other parties while you're in litigation? All of that stuff, that's procedure. Civil procedure is the procedure that attends cases of a civil nature. Okay, that's a little tautological, sorry. In our system, what that means is basically every case that is not a criminal case is subject to civil procedure, because the way that we have divided up our litigation in America is with two kinds of procedure. Criminal procedure that goes with criminal cases where you have a prosecutor prosecuting a defendant accused of a crime, and everything else, which is civil. So you don't have to do it this way. Other countries have organized things differently. A lot of countries have a whole separate system and often a whole different court system for administrative cases where people are suing the government or suing to not let the government impose some obligation on them. In our system, that stuff actually falls under civil procedure. So your tort case and your contract case is civil procedure, but so is your constitutional law case, and so is your administrative law case, civil procedure. So this is a really huge area. And I'll just add one more word here. In this class, we will be focusing almost entirely on federal civil procedure. What that means is the civil procedure rules that go along with the federal courts as opposed to the state courts. This becomes actually a very thorny issue in our civil procedure, because rather than having one court system that is ruled by one set of rules, we have 51 court systems, or actually even more, because we have 50 states, we have the District of Columbia, we have Puerto Rico, and we have the federal system. And all of them interact in very strange ways that we will spend a considerable amount of time puzzling out. But our focus in this class will be the federal system. And that's partly because everywhere you go in the United States, the federal system will be the same. It's always federal. But it's also partly because a lot of the state systems are actually modeled on or roughly similar to the federal system. And so it gives you a good starting point to understand the civil procedure regime of whatever place you end up practicing in. Okay, so federal civil procedure and civil procedure in general, you can think of it as the law of lawsuits. Basically, these are the rules and laws that govern how a lawsuit runs. What kind of rules are these? So you can think of one kind of rule as a kind of drive on the right side of the road rule. So some rules are like that. It doesn't really matter if we choose the right side of the road or the left side of the road. It's not like somebody gets advantaged or disadvantaged because we've chosen the right side of the road or the left side of the road to drive on. You just need to choose a side so that people aren't getting in accidents all the time. And so in a sense, although it's really important to obey the rule about driving on the right side of the road, nothing much really rides on which side we choose. The choice, in a sense, is arbitrary. Civil procedure rules are not like that. Civil procedure rules inevitably benefit some groups of people and disadvantage other groups of people. They have systemic effects that can be really foundational, like how easy is it to vindicate your rights? How easy is it to impose legal obligations on others? How much legal protection do you have before a legal obligation is imposed upon you? All of those things have systemic structural effects that are not distributed evenly across the population. And so one of the things that we'll focus on as we move through our study of civil procedure is who gets affected by this rule and how do they get affected. And as we'll see, civil procedure, just like all areas of the law, is in a state of constant motion. Things change all the time. And it gives you a way of tracking who gets affected by those changes. And it also gives you an idea of how changes can be made, even by people like us, litigating in the federal courts. One other thing about the law of lawsuits is that it governs a lot of different people and institutions. So one of the things it governs is court power. How do courts get authority to impose their adjudicative results on us litigants? It also governs us litigants. How do we behave in court, and not just in court, but in litigation in general? And not just in litigation, but even in things that might potentially lead to litigation, like, for instance, contracts. So even if you're a lawyer who mostly drafts contracts, you have to be thinking about the civil procedure implications of your actions. And because of that, because civil procedure really looks at the way that the lawsuit is run rather than the specific substance of liability and legal obligation, we call it transsubstantive. Transsubstantive just means it goes across the substantive areas that determine liability and determines how liability gets determined. Civil procedure rules, furthermore, are binding, so you have to know them to be a minimally competent lawyer. But they're more than just binding. They are also a way of strategizing. They allow you to play the game to maximize your chance of winning. And so to be a competent lawyer, you have to know civil procedure. To be a good lawyer, you have to be able to use it in a strategic way. Like I said, civil procedure ends up determining a lot more than just the conflict between two parties to a lawsuit. It ends up having really foundational, fundamental effects on what law means in our country. So, for instance, how do we think about what serves justice? And how can litigation help ensure that justice is served or prevent justice from being enacted? What are the legal rights that we have to, as against others, and what legal duties do we have to others? That's something that gets determined through civil procedure because the kinds of lawsuits that can be brought and the ways that outcomes come out of them is largely determined through procedure, even though procedure itself is transsubstantive and doesn't really care all that much about your particular rights in torts or your obligations in contracts. Nevertheless, the way that we make decisions about this ends up depending a lot on the rules of civil procedure. Civil procedure also ends up organizing a lot of our most powerful institutions in this country. So, how courts work, how they relate to one another, how the hierarchy is formulated, all of that plays into and gets expressed in civil procedure. It's also one way that we try to manage the extremely complex kind of jalopy that we have developed of the federalist system. In other words, the interaction of federal and state laws and courts. So there's a huge systemic aspect, structural aspect to civil procedure. And there's also an individual aspect that asks, what do I do in a lawsuit? How do I be a plaintiff? How do I be a defendant? That gets determined through civil procedure as well. So as we learn about civil procedure over the course of this semester, we have to operate at all of these levels and be asking all of these questions. And to some extent, we break them up into different parts of the syllabus where we focus more on some issues rather than others. And I'll talk about that in the next lecture. But to some extent, those first two questions really permeate everything we talk about with civil procedure and legal procedure of all kinds. So I hope that gives you a basic idea of what we're working on here and why we are gathered here today and for this semester. And in the next lecture, I'll talk a little more about how the class will run and how the syllabus is organized, and also give you a little heads up for the first set of readings.